You
I'll
asked
out
me.
The door, and then I'll call a patrol car.
You
and
asked
and then
me.
You can deal with the patrolman.
You asked me what paperwork it was that I was waiting on. It's none of your business.
You don't tell me what's my business. This place here is my business.
My personal
All right?
paperwork is none of your business.
They asked you to leave, and I'll throw you out.
He's asking me what paperwork. Don't you dare touch me. He's asking me what paperwork I'm waiting for, and it's none of his concern. It is for my court case.
Hello, and welcome back to Legal Dissent, where we evaluate your constitutional rights before they're taken away. As always, if you enjoy our content, please subscribe, like, and comment to help spread our message of accountability across the country. During this video, we will go fairly deep into the legal world of civil versus criminal cases, the statutory requirements for assault and battery, and also qualified immunity. So if you're looking for a video that shows you the drama surrounding a police-citizen encounter, then you probably just need to go watch the original video, which is located in the description below. But if you're interested in actually learning what the law is and how it applies, then continue watching our video and we'll do our best to educate you in an entertaining manner. Today, we're going to evaluate a video submitted by a subscriber that was uploaded by the YouTube account Nancy Ann just a little over a month ago in Schenectady, New York. As always, the original video, the channel, case law, statutes, and other sources are all included in the description below, so let her know that Legal Dissent sent you. Nancy is waiting in the lobby of the Child Protective Services building when she is confronted by Theodore Paniccia, who is a special patrol officer for the county sheriff's department.
I'm sitting here waiting for my paperwork. She told me to sit out here and wait.
I asked you a simple question, and you gave me a lie. I'm not paid here to take you.
You
I'll
asked
out
me.
The door, and then I'll call a patrol car.
You
and
asked
and then
me.
You can deal with the patrolman.
You asked me what paperwork it was that I was waiting on. It's none of your business.
You don't tell me what's my business. This place here is my business.
My personal
All right?
paperwork is none of your business.
They asked you to leave, and I'll throw you out.
He's asking me what paperwork? Don't you dare touch me.
This is absolutely infuriating. She has every right to be in the building waiting for her case information. The officer has no right or legal justification for demanding to know what kind of case she has, what type of paperwork she is waiting for, or anything other than if she has a legitimate reason to be in the building. Therefore, the conversation should have ended as soon as she said, "I am waiting for my paperwork." There is a ton of confusion that revolves around the term assault and battery in our society, and especially in the YouTube comments. First, there are two types of court systems within our country, civil and criminal. Criminal cases are cases that have potential imprisonment punishments, and these cases are not filed by individuals, but by the prosecuting attorney of the county on behalf of the people that the prosecutor represents. Civil cases are cases brought by individuals that seek financial compensation for damages conducted by another party that may not have broken the law, but did violate some type of contract or exhibited negligence of some sort. Assault and battery claims are found in both arenas of law, civil and criminal courts. Assault and battery is going to be defined by your state's laws, and that means that there will be multiple definitions and applications depending on where you live. This video was filmed in New York, so we will evaluate the facts in the light of New York's laws. We will first analyze that the officer could be potentially guilty for criminal assault in the state of New York when he fully extended his arm with an open hand to slap at the phone and at the videographer. There is no criminal battery statute in New York, and criminal assault and battery is fully encapsulated in Section 120 of the New York Penal Code. This code defines that assault occurs when an individual causes injury to another person with intent, recklessly, or with criminal negligence by means of a deadly weapon or a dangerous instrument. The main element of the statute is that the offense must have included some type of physical injury. The New York Court of Appeals held in a 2007 case, People v. Chittick, that the definition of physical injury means impairment of physical condition or substantial pain. The court went on to explain that substantial pain cannot be defined precisely, but it can be said that it is more than slight or trivial pain. Pain need not, however, be severe or intense to be substantial. Beyond these generalizations, there are several factual aspects of a case that can be examined to decide whether enough pain was shown to support a finding of substantiality. They eventually held that the defendant was guilty of inflicting substantial pain by biting an individual hard enough that it broke a fingernail and caused the individual to bleed. This obviously goes above what Officer Paniccia did in this instance. So based on New York law, I highly doubt that he would be found guilty of criminal assault. However, there's still the possibility for a civil case of assault and battery. According to the 1998 New York First Appellate Division case, Sharkey v. Altman, a civil assault is an intentional placing of another person in fear of imminent, harmful, or offensive contact. And a civil battery is an intentional, wrongful physical contact with another person without consent. The Second Appellate Division of New York held in 2002 in Bastine v. Soto that in order to recover damages for assaulting a plaintiff, the plaintiff must prove that there was physical conduct placing the plaintiff in imminent apprehension of harmful contact. For battery, the plaintiff must prove that there was bodily contact. The contact was offensive and that the defendant intended to make the contact without the plaintiff's consent. In this case, the officer did make contact with the videographer. It's clear that he intended to make the contact, so the only element remaining is if the contact would be considered offensive or not. This is an element that is determined by a trier of fact as opposed to a trier of law. This requires the input of a jury as opposed to simply a judge. I do believe, in my personal opinion, that this would be considered offensive contact. However, like I said, it would be up to a jury to decide. Because the officer is operating under the color of law, this now brings us to the element of qualified immunity. For those of you who do not know what that is, qualified immunity grants government officials performing discretionary functions immunity from civil suits unless they have violated clearly established statutory or constitutional rights that a reasonable person would have known. The test for if a government official is subject to civil liability or not is determined by the United States Supreme Court in Harlow v. Fitzgerald. This case established that an official is immune if they believe in good faith that their conduct was legal and if the conduct was objectively reasonable. As I've already talked for quite a bit, and I'm sure most of you have already skipped ahead, we'll come back to this later on.
He's asking me what paperwork I'm waiting for, and it's none of his concern. It is for my court case. And I will furthermore get a lawyer if he puts his hands on me. Amanda told me to wait out in the waiting room, which is what I am doing, waiting for my paperwork. Thank you. And I will continue to record. Learn how to tell the time? I got the time. Now I will bring a lawyer in here and have you arrested.
Just a real quick note here. Please do not ever say things like this when you're having these types of confrontations. First, lawyers do not arrest people and people do not file charges. The prosecutor files charges on behalf of the people and police officers make arrests. Saying things like, I'm going to have my lawyer come in and arrest you, damages your credibility and makes attorneys much less likely to take your case. The less you say in these situations, the better. Remember to exercise your rights, and one of the most powerful rights you have is the right to remain silent.
I am calmly waiting for my paperwork as I am being harassed.
Where's he gonna go?
I'm waiting for my paperwork like Amanda told me to.
You got paperwork from her? No.
Sitting here being harassed by security, and I am bringing this video to my lawyer.
There's no use of telephones in here. I'm not gonna tell her again.
For my rights, I can record. And if I have to, I can stand right outside that exit door and I will record.
Of phones in this area.
Where does it say that?
Right there. Notice. And it's right here when you sign it. It's right here. Here, you want to record it? Here. Read it. You're violating the law, right?
So we are not able to get a good look at the notice on the table that allegedly states that you can't record or use phones beyond the lobby doors. It is important what the exact verbiage of the notice states to determine if she was violating a policy or not. While policies are important, they do not trump your First Amendment rights or any of your constitutional rights. However, the government does have the ability to restrict speech to reasonable time, place, and manner restrictions if there are legitimate government interests in play. Theoretically, forbidding the use of recording devices in a child protective services building could have very legitimate government interests that would reasonably allow such a policy. For example, if they facilitate victim interviews at this building that requires minors or other victims to be going in and out of the lobby, it is reasonable to not record them within the restricted lobby. However, a professional police officer would have calmly informed the videographer of this policy and politely directed her to where she could legally film, as opposed to attempting to slap the phone out of her hands.
I said no one used recording.
But he can put his hands on me, right, and go like this to try to smack my phone out of my hand?
You tried to hit me with that phone.
No, I didn't. I have it all on recording.
Stuck it right in my face.
I don't know about you, but I've never been in more fear of my life than when someone has tried to hit me with their phone. This is obviously a lie, and rewatching the footage, the officer fully extends his arm to slap the phone out of the videographer's hands. This is not a defensive movement or posture. Going back to our discussion on qualified immunity, this lie is evidence of the fact that the officer reasonably knew that his conduct was not legal or objectively reasonable, because he had to lie to cover up his behavior and create some type of affirmative defense for his illegal and unreasonable conduct.
I have it all on recording.
Are you waiting for somebody right now?
I'm waiting for my papers. Now he is locking the door on me.
At this point, they lock her out of the building, and the recording shortly ends thereafter. We'll continue to monitor her channel to see if there's any future updates, but we hope that she files a complaint and seeks civil damages against the officer. What do you think? Did the officer behave reasonably? Do you think qualified immunity will apply? Let us know in the comments below. Also, please leave feedback on how we can get better and what you'd like to see in the future. We're still a new channel and we're trying to figure a lot of stuff out, so constructive criticism is always welcome. Thanks again for joining us, and we'll see you next time right here on Legal Dissent.